Good morning, everyone, and thank you for joining us today to learn more about how to help people with disabilities of all ages protect their eligibility for means-tested government benefits when they come into a sum of money, such as proceeds from a settlement that puts them over the financial limits for Medicaid and/or Supplemental Security Income benefits. My name is Sarah, and I'm the Director of Outreach and Community Relations at NYSARC Trust Services, and I'd like to introduce you to Nadia Arginteanu, NYSARC's trust attorney, who will be presenting today's webinar.
Good morning, everyone.
NYSARC Trust Services is a not-for-profit organization that was established by the ARC New York in 1972 and has helped more than 20,000 people with disabilities protect benefit eligibility and improve their quality of life. NYSARC hosts this free webinar series to help educate people, families, and professionals about irrevocable supplemental needs trusts and how to help people with disabilities protect benefits now and also preserve future benefit eligibility. Following today's presentation, you'll receive an email with more information about upcoming webinars that you might be interested in. And we also ask that you please take a few minutes to provide us with some feedback on this program by completing a brief survey. Your input is greatly appreciated and will help us improve this presentation in the future. So before I turn things over to Nadia, I'm gonna quickly run through a couple of housekeeping items. You'll find copies of the slides and a brochure with more information in the handouts area for your reference. Please take a few moments now to download those handouts. They will be available for download up until the end of today's presentation. And if you're unable to get those, feel free to give me an email and I will send them over to you. Everyone is muted by default, but we encourage you to use the chat and/or questions feature in the toolbar to submit any questions that you have throughout the presentation. Based on the time that we have, we are going to save questions until the end, and we'll run through those in the last 15 or 30 minutes of the webinar. We'll do our best to get through as many questions as possible. This webinar is being recorded, and if you have additional questions after today's presentation, or you'd like a copy of the recording, please contact us. Our contact information is located on the last slide. Now with that, I'm going to turn things over to Nadia to get started.
Thank you very much. Good morning, everyone, and thank you again for joining us. For today's presentation, we've identified a few learning objectives that we hope at the end of your 2 hours with us, you'll have learned these things. The first is we want to talk about the importance of considering benefit eligibility for a person with a disability when they come into a lump sum of money, such as a lawsuit. And we want to help you learn how to use various different trust options to help that person qualify or maintain their eligibility for means-tested government benefits, even though they do have that lump sum. We're going to talk a little bit about the difference between individual special needs trusts and pooled special needs trusts to help you identify what type of trust the individual you're working with could benefit from. And then we're going to go into how those different types of trusts can be established and funded. And then once you have that trust set up, how the money in the trust can be used to improve that individual's quality of life. The first question here is, why is it important to consider someone's benefit eligibility when they come into a lump sum of money? And that's important because for an individual with a disability, a positive outcome from a personal injury lawsuit, if they get a lump sum of money from a court order or a settlement or maybe a structured settlement, can actually have a negative impact on their quality of life, which sounds counterintuitive, but when someone relies on means-tested government benefits to provide them with some of the necessary things that they need for their lives, such as housing or medical care, coming into a sum of money that will make them ineligible for those benefits could really have a negative impact on their life. So we ask people to consider that if you're working with someone who is currently receiving means-tested government benefits or who you think might need to be eligible for those benefits in the future, to consider sheltering at least some of the funds they receive in some form of special needs trust so they can maintain their eligibility for those benefits. So a lot of times when we have people who come to us with a lump sum of money, their lawsuit is over, there is amount of money that they've been awarded, and now they need to figure out what to do with that money. And there are a few options. The first option is that those funds can be given directly to the individual. But the problem with that is that could affect their eligibility for benefits. So we kind of encourage people to consider options 2 and 3 and see if that's going to better serve the people they're working with. Your other option is to create some form of first-party special needs trust and put those settlement proceeds into that trust to make sure that that individual stays below the resource limits for the government benefits that they receive. And the third option would be to consider using a combination of a special needs trust and an ABLE account, which is a special type of tax advantage saving account for someone with a disability, to shelter those funds. And the combination of those two will help protect that individual's eligibility for government benefits. So for those of you who don't know, a special needs trust, or sometimes referred to as a supplemental needs trust and often abbreviated just to SNT, is a special type of irrevocable trust that holds the assets of a person with a disability, but those assets are sheltered, so they're not considered a countable resource when you're looking at that person's eligibility for means-tested government benefits. So putting the funds in the SNT protects their financial future and allows them to use those assets to supplement their government benefits. These SNTs are permissible under New York state regulation and federal law and regulation, and they're primarily used to protect someone's eligibility for Medicaid and or Supplemental Security Income, or SSI, but they can also be used to protect benefits for some other types of benefits. There are a lot of benefits to using an SNT to shelter someone's lump sum funds like this, and the main one is that once those funds are in an SNT, it's going to help your client maintain their current and future eligibility for means-tested government benefits. And the reason why that's important is it helps them kind of secure a more stable financial future without jeopardizing their benefits. They're then allowed to protect those funds and use them to enhance their quality of life. And by putting them in an SNT, you avoid frivolous spending and mismanagement of funds. You avoid a situation where someone is kind of forced to spend the money they receive as quickly as possible in order to maintain their eligibility for government benefits, instead of having kind of the luxury of using that money over time to enhance their quality of life. And especially for the attorneys in our audience, I think another benefit of using an SNT is that it helps give that attorney the peace of mind, knowing that they took proper steps to ensure their client's benefit eligibility when receiving that settlement, kind of filling their duty to their client. So when we're talking about using an SNT to protect excess resources or assets, it's important to know the limits of how much money someone can have before they do have an issue with eligibility. And one thing that is really glaring here is that for someone who receives SSI benefits, an individual having as little as $2,001 a month could cause them to lose their benefit eligibility. We also put on here the Medicaid resource limits because you may have an individual who isn't receiving SSI but is receiving Medicaid, and for them there is a higher resource limit. However, it is still often lower than what someone's monetary settlement might be. There are a few examples here on this slide of what types of excess resources someone could be looking to shelter. Though in this presentation, we're kind of gearing this more to someone who has come into funds from some sort of lawsuit, all this information about sheltering excess resources also applies to someone who comes into a lump sum of money from a direct inheritance from a family member or loved one, who has a retroactive Social Security award that puts them over the resource limit, or someone who is accruing benefits from accruing funds from survivors' benefits, and again has an issue with the resource limit. So all of this information really applies to those situations as well. And while we're on the topic of the income and resource limits for benefit eligibility, we like to share this information too, just so it lets you know that for people who have an issue with their income for Medicaid eligibility, this information about using first-party pooled trusts applies to them as well. And you could have a situation where you have an individual who might have an issue with income and an issue with resources. And in that situation, this information could help you find a trust that would help solve both those problems at once. So we always like to share this information. So as we referenced earlier in the presentation, when you've determined that someone does need a special needs trust, there are two primary options. For someone who is trying to shelter funds that are in their name, it's their money, they're going to need some form of first-party SNT. They can form an individual SNT. Sometimes those are referred to a D4A trust from the regulation that permits them. Or they might look at a pooled SNT, which are often referred to as D4C trusts. And in the next few slides, we're going to go over kind of the similarities and differences between an individual trust and a pooled trust that will help you hopefully better determine what would be the right fit for your client. So a first-party individual SNT. This is going to require an attorney to draft the trust document. They're going to write the trust for your client. The family or the client, they're also going to need to identify an appropriate individual to serve as trustee. There's a benefit to that. It gives the individual the flexibility to choose who they want to serve as trustee. Oftentimes, people choose a family member, sometimes a friend. Sometimes lawyers or other professionals can serve as trustees, or banks often provide professional trustee services. So this gives the individual that kind of flexibility, but it's also important to keep in mind that there's a lot of responsibility when it comes to being a trustee. This type of trust can be used to shelter an excess of resources or eliminate a Medicaid income spend down if someone has a spend down issue. However, you can only use this type of trust up to age 65. And with the first party SNT, we always want people to remember that when the beneficiary passes away, any funds that are in that trust are going to have to be used to repay any type of Medicaid lien for services provided during the life of the beneficiary. And you can keep in mind here that if there is a Medicaid lien that was negotiated as part of the individual's lawsuit settlement, those funds will already have been taken care of. So it's going to be whatever Medicaid lien there is above and beyond that lien that was previously paid. When we're establishing an individual trust, like I said, you're going to need an attorney to draft the trust document. And what that attorney is also going to do is submit that trust document to the Social Security Administration to be approved. We wanted to point out here that there is a recent update to the Social Security POMs, which are guidance documents from the Social Security Administration. And we want attorneys to keep in mind that if they are submitting a trust to the Social Security Administration, they may be required to submit an application for the approval of their fees before they charge their fees. So we just wanted to share that information, and that POM section is going to be hyperlinked in the presentation after you download it. An important thing to keep in mind here is that you need someone who has legal capacity to create the trust document, to authorize the attorney to draft the trust document and then to sign the trust document. So, excuse me, that can be the disabled beneficiary themselves, but if they don't have capacity to sign the trust document themselves, it can be a parent, a legal guardian, or an agent under power of attorney. So there are those options if someone doesn't have capacity. A first-party pooled trust, as an alternative to a first-party individual trust, does not require an attorney to draft the trust document. It's an affordable alternative to an individual trust because the not-for-profit organization that serves as trustee has already drafted the trust document and submitted it to the Social Security Administration for approval. So that part is already taken care of. There is a professional individual to serve as trustee. Oftentimes, this can kind of ease the burden for the family of finding a suitable individual to be a trustee, or if there's someone who wants to be trustee, but it's a lot of information for them to learn, working with a professional trustee can make it easier for the family because there's someone else to handle the trust administration. A first-party pooled SNT is available to someone even after the age of 65, unlike an individual trust. The reason why pooled trusts are called pooled trusts is that all the funds in the trust are pooled for investment and management purposes. However, trust activity is going to be tracked in separate individual sub-trust counts. So for the individual using a pooled trust, their user experience is really the same as it would be with any of us using our own bank account. They're going to get monthly account statements from their not-for-profit trustee that are going to show the activity in their individual bank account. The payback for a pooled SNT after the beneficiary passes away is a little bit different than with the first-party individual SNT. With the individual SNT, there has to be Medicaid payback. With the pooled trust, the federal regulations that allow pooled trusts allow the not-for-profit organization to retain some of the funds after the individual passes away in lieu of paying a Medicaid lien and using those funds to help people with disabilities. For example, the ARC New York and NYSARC Trust Services, we use remainder funds to fund an unfunded corporate guardianship program for individuals with disabilities served by ARC New York chapters, and to support unfunded recreation opportunities for people served by ARC New York chapters. So when we're talking about when you want to choose a pooled trust over an individual trust, one of the main reasons is that choosing a pooled trust can be affordable to set up and affordable to maintain. For a lot of people with an individual trust, there isn't really enough money to justify setting up an individual trust because of the cost it would take to pay an attorney. So a pooled trust makes it easier for someone to access the benefit of a special needs trust who might not have as much money. A pooled trust can also be opened relatively quickly because the trust document has already been approved by the Social Security Administration. And one of the benefits for some of our professional listeners here is that you can assist your client with a trust application and kind of keep those services in-house instead of having to look to an attorney or another professional to help your individual find the pooled trust that would work for them. So on the bullet points on this slide, we have some kind of things to keep in mind when you're considering whether a pooled trust would be the right fit for your client. If your client wants to maximize the value of the funds that they have, this is a great example of why a pooled trust is great for someone who might not have enough money for an individual trust, but it's also really good for someone who might have more money and they could maybe afford to have an individual attorney draft a trust for them, but using the pooled trust helps them get greater use out of that money. Again, if your client has a more modest amount of money, a pooled trust could be a good option for them. If your client doesn't have an appropriate person to serve as trustee of an individual trust, this is a major one. We like to encourage people to keep in mind that serving as trustee of a special needs trust is an important responsibility. And as a trustee, the individual who's chosen is going to have the fiduciary responsibility to their client, to the individual, to the beneficiary, to make sure that the funds are used appropriately. And there are a lot of rules and regulations and record keeping that go into that duty. So if you have someone that is willing to take on that responsibility and is going to learn the rules and collect the documentation and do their due diligence when it comes to distributions from the trust, then they might be a good person to serve as trustee. But if an individual doesn't have someone who's going to be able to properly serve that role, choosing a pooled trust is a great option because the not-for-profit organization who serves as trustee is going to have that knowledge, that expertise, and the tools in place to administer the trust to make sure that everything is done appropriately and that the individual's benefits aren't impacted. Another reason that choosing a pooled trust or another form of professional trustee could be a good choice is if the beneficiary has complex medical needs. If their disability and their government benefit structure are going to be more complex, again, it might be beneficial to have a professional involved who's familiar with those rules and regulations that are involved, as opposed to asking a family member to take on the burden of all that work. So in that situation, a pooled trust can really help. And if you have a client that you're working with who's over 65, they cannot use an individual SNT. They have to use a pooled trust. So for them, this is really the only tool that's going to be available to shelter their funds if they come into some sort of lump sum. Establishing a pooled trust is different than establishing an individual trust because, like I said, the trust document is already written and approved by the Social Security Administration. So if you have someone who wants to use a pooled trust, they're going to have to complete the joinder agreement, which is basically the application that a not-for-profit that runs a pooled trust will have, and have that notarized and submitted to the trust company with whatever supporting documentation they require, which is often going to be some confirmation of the beneficiary's Social Security number and benefits, and also some form of funding. The joinder agreement is really basically a contract between the beneficiary or their legal representative and the trust company saying that they want to participate in the trust. And the joinder agreement is really just demographic information about the trust beneficiary. We always like to point that out because we know that when people have had experience with Medicaid applications and benefit applications, that it can require a lot of information that's not readily available to the individual and their family. But with a joinder agreement for a pooled trust, it really is generally going to be information that someone's going to be able to sit down and fill out without too much burden. So that's, again, one of the benefits of a pooled trust. Similar to establishing an individual trust, you do need someone who has the legal authority to sign the joinder agreement on behalf of the individual. And again, that can be the individual themselves if they have capacity, but if they don't, a parent or grandparent can sign the joinder agreement. An agent under power of attorney that has the appropriate powers can sign the joinder agreement, or a guardian who has the appropriate powers. A court order can also direct the execution of the joinder agreement and funding a trust on behalf of the individual. We often see that with a court order, especially when it's a court-ordered settlement from some sort of lawsuit. They'll include that information right in the order that resolves the case. And I think it's just important to keep in mind that if the account is established by a court order, if there is a guardian or an agent under power of attorney signing the joinder agreement, that the trust company you're working with is probably going to require seeing copies of those documents along with the joinder agreement as they're reviewing the initial application. When we're talking about funding the trust, there's a few different things to keep in mind. A trust, whether it's an individual trust or a pooled trust, can be funded with a lump sum or a structured settlement, such as an annuity. We encourage people to keep in mind that in order to avoid loss of benefit eligibility, the trust should really be funded in the same month that the money is paid out to the individual. And along those lines, the funding can come directly from an attorney escrow account, an insurance company, a settlement company. The money doesn't have to go into the individual's personal bank account before it comes to the trust company. And part of the reason why that's important to keep in mind is that some people mistakenly think that if the money is just sitting in the attorney escrow account, that it won't impact the individual's benefit eligibility. However, the Social Security Administration is going to consider that money the individual's, even if it hasn't been paid out yet, because they're entitled to it. So that's something to keep in mind. We always encourage people to ensure that any court orders or settlement agreements that are involved in a lawsuit clearly reference the creation and funding of the chosen variety of special needs trust, if possible. And along those lines of when you need a court order, if the funds are coming from an annuity or structured settlement, so there's going to be some form of payment, whether it's monthly or annually, going to the individual, those payments need to be irrevocably assigned to the chosen SNT by court order. Otherwise, those won't be sheltered for the individual's benefit eligibility. So that's something important to keep in mind. When we're talking about funding the trust, we also want to encourage people to consider whether a Medicare set-aside is necessary. That's really a topic for another conversation, another presentation, but we do want people to keep in mind that if their settlement agreement or court order requires that a certain amount of funds be put in an MSA, that should be considered before money is put into the trust to make sure that everything is done along the lines of what the settlement agreement or court order requires. So now that we've talked about some of the similarities and differences between what an individual trust or pooled trust can pay for, and given some information about what type of trust might be the best fit for your client, the next question becomes, what can an SNT pay for? And this information is going to apply whether your client uses it as an individual trust or a pooled trust. These same rules apply. The funds in an SNT can be used to enrich the quality of life of the person by paying for goods and services that their benefits don't provide. The phrase that is often used when talking about how the funds in an SNT can be used is that the funds are intended to supplement, not supplant or replace, the services otherwise available through government programs. So what this means is that the money in an SNT is supposed to pay for things that go above and beyond what the individual's benefits pay for. So, for example, a trust can be used for things that are life enhancing that aren't covered by benefits, things that are uncovered medical expenses that their benefits don't pay for. But what the trust can't pay for is something that their benefits would provide. So that, for example, if someone receives SSI, the trust can't pay for anything that would be in-kind support and maintenance, such as food or shelter, without reducing that person's eligibility for government benefits. So the way that I encourage people to think about this is to think about the money in the SNT to be what's above and beyond what their benefits can pay for. And what I always say when I talk to people about this is that there is far more that the trust can pay for than what the trust can't pay for. The touchstone of what we use to determine whether or not a payment is an appropriate expense for an individual is first whether it's covered by government benefits, and then whether that payment is for the primary benefit of the trust beneficiary. So really almost anything that is going to be for the primary benefit of the trust beneficiary but not covered by government benefits is going to be something that an SNT can pay for. And what I would really encourage people to do, especially if you're working with someone who you know is going to be getting a settlement and have this sum of money, to talk to them about how they want to use that money, about what they want that money to do for their family and their lives, and let them know, what types of expenses can be paid for once the money is in the trust, if there's something they should pay for before the trust is funded, just keeping that in mind, because whether an individual or a pooled SNT, these trusts are irrevocable. That's what creates the protection for government benefits that we're looking for. So once the money's in the trust, it can't just be taken back out because someone changes their mind. So this conversation about what an SNT can and can't pay for is really important in terms of setting expectations with the people you're working with about how the money in the trust can be used once it's in there. There are some situations where even though someone is receiving SSI, that we might consider paying for housing, if it's going to enhance their quality of life to an extent where getting that impact in their government benefits would be kind of worth it, a cost-benefit analysis for that particular individual. But that's really on a case-by-case basis. So what we encourage people to do is start with the assumption that if someone has SSI, we can't pay for anything that SSI would cover unless we're in kind of extraordinary circumstances. And I think that ties into a greater concept, which is that we're really looking at each individual and their living situation when we're determining what is an appropriate expense and whether it's something the trust can pay for. So if you have someone that you're not sure the trust can pay for something, you should feel free to contact us and we can help you work through that information to let you know what the trust can do in that particular situation. So before we get into a conversation a little bit about EABLE accounts, we just wanted to provide you with some information about the different trust programs that NYSARC administers. The unrestricted fund is a third-party trust that allows a parent or other loved one to set aside some of their funds for the benefit of an individual with a disability. Community Trust 1 and Community Trust 3 are our first-party pooled trusts for someone with lump sum. So those are really the trusts that would benefit someone in this situation who's coming into a lump sum from a lawsuit settlement or from some other source, and they need to shelter it. And something that's unique about Community Trust 3 is that because this trust is designed for a larger amount of money, there could be a situation where there's enough money left in the trust when the individual passes away that we can pay their Medicaid lien. The trust would retain a portion of funds for the benefit of people with disabilities, and then there would be some money remaining that the individual could leave to family members as designated in their joinder agreement. So that is something very unique to Community Trust 3 that allows someone to potentially leave money to their family members, loved ones, to other organizations that are meaningful to them if they do have a large sum of money that they're looking to shelter. And then Community Trust 2 is our pooled SNT that's designed to help someone who has excess monthly income, like we referenced on one of the earlier slides, and they can use that trust to deposit excess monthly income on a monthly basis and maintain their eligibility for community-based Medicaid services. So when we talked about what options there are when someone comes into a lump sum of money, we talked about that using an ABLE account in connection with an SNT could be a good fit for some people. If you're not familiar with an ABLE account, these were born in 2014 with the passage of the Achieving a Better Life Experience Act to create another option besides SNTs for someone with a disability to shelter money. So ABLE accounts are not trusts, they are tax advantage saving accounts designed to help people set aside money for qualified disability expenses. They're actually kind of inspired by 529 college savings accounts. The ABLE account is codified as 529A in the Internal Revenue Code. So it's kind of an option similar to a college savings account. There are a few special kind of requirements about how and when an ABLE account can be used. One of those major requirements is that the individual must be disabled prior to the age 26 to participate. So there are going to be some people who are disabled later in life due to an onset of illness or an injury who won't be able to use an ABLE account based on just that threshold requirement. But for those who are eligible for an ABLE account, some of the benefits are that the deposits into an ABLE account can come from any source. So it could be the individual's own money, it could be money from a parent or family member who wants to put some money aside for the individual. The money can come from any source. However, the maximal annual contribution, at least for 2019, is $15,000 a year. And that's $15,000 a year from any source. So if I put in $5,000 to my ABLE account, the maximum that everyone else I know could put in is $10,000 a year, $10,000 in that same calendar year. So that's something to keep in mind, particularly if someone has a settlement that might be over $15,000. One of the benefits of an ABLE account is that the account balance can get up to $100,000 without affecting SSI eligibility. With the ABLE account, these are all required to be self-administered by the account holder. So it's going to be the responsibility of the account holder to maintain a record of expenses and receipts to show that purchases from the ABLE account were made for qualified disability expenses, or QDEs, which is the requirement of how the funds in an ABLE account can be used. And really, when you're evaluating whether an ABLE account is a good fit for someone, they really are kind of best for an individual who is capable enough to maintain a level of financial independence and use the ABLE account, but is also still able, or at least able with the help of someone else, to maintain the record they need to of expenses and receipts to make sure that they can prove that the funds in their ABLE account were used appropriately for qualified disability expenses. So like I said, funds in an ABLE account can be used to pay for qualified disability expenses related to the person's blindness or disability. And these are some examples of what kind of falls under that umbrella. We do like to point out that the government has determined that housing and basic living expenses do fall under this umbrella of qualified disability expenses, which definitely does do something to broaden what this can be used for. And also, depending on an individual and their needs and their disability, what is a qualified disability related expense? Something that is for their education or health and wellness can be very broadly defined. But we also want people to know that if distributions from their ABLE account are used for not qualified disability expenses, there could be tax consequences and there could be an impact on the person's eligibility for benefits. So again, that's where we emphasize that it's important to keep records and have that information available if someone's asking you to confirm that the funds were used appropriately. So here are some kind of pros and cons about ABLE accounts that we hope will help you evaluate whether an ABLE account could be a good fit for the people you're working with. So some of the advantages of an ABLE account is that up until that first $100,000, the funds in an account are not an available resource for benefit eligibility purposes. That money in the account will grow tax-free, and any distributions from the account for qualified disability expenses are not going to be considered income. Much like a pooled trust, an ABLE account is inexpensive to set up and maintain, but there are some fees associated with the account. And really one of the primary benefits, at least in my opinion, of an ABLE account is that because you can use the ABLE account for housing and basic living expenses, and the way that that has been interpreted by the government, someone who's receiving SSI can use their ABLE account to pay for something that their SSI benefits would pay for without causing a reduction in their SSI benefits. So the way that that looks is that if someone has SSI, the ABLE account could kind of subsidize their rent, maybe help them get into a nicer home without causing a reduction in their SSI benefit. So that is definitely a situation where if you have someone who you think would really benefit from that, maybe at least putting a certain amount of money in an ABLE account just to subsidize their housing would be a really good benefit for that client. But kind of as we've referenced, there are some disadvantages to the ABLE account. One of the main ones is that it's only available to people who have an onset of disability prior to age 26. So some people are, immediately not able to participate. There is that annual contribution limit, whereas there's no limit to the amount of money you can put in an SNT in a calendar year. But that's something that we want people to consider, that if you think an ABLE account could benefit your client and they have $50,000 coming to them, you could put $15,000 in an ABLE account and put the rest of the money in an SNT and kind of use a combination of an SNT and an ABLE account so your client really gets the benefits of both of these programs. Something to keep in mind with an ABLE account is that if that balance ever does grow to be over $100,000, that money over the $100,000 is going to count towards the resource limit for SSI or Medicaid eligibility. So that's an important thing to keep in mind if down the road an ABLE account has grown to be that large. A person can have multiple SNTs, but they can only have one ABLE account. That's particularly important to keep in mind when you're remembering that the funding is $15,000 a year from any source. With SNTs, an individual can have a third-party SNT in their name where a grandparent is sheltering money for them, and they can have a first-party SNT in their name where they shelter their own funds. So there's a little bit more flexibility in terms of that. With an ABLE account, there are various states, including New York, that offer a state ABLE program that your client can take advantage of if they think an ABLE account is the right fit. But the investment options available there for the funds are a little bit more limited than they might be if you're working with a not-for-profit pool trust, or if you have an individual trust where your trustee can really make changes to the investment options whenever they feel it's appropriate. And so that in that way, the investment options are a little bit more limited with an ABLE account. Another disadvantage of the ABLE account, which is important to keep in mind, is that all funds in an ABLE account are going to be subject to Medicaid payback upon the death of the account holder. And we've already talked about earlier in this presentation that when someone has an individual SNT, those funds are subject to Medicaid payback when the individual passes away. However, if it's a third-party trust, so for example, I'm putting money into a trust for my child, the money in that trust would not be subject to Medicaid payback upon the death of the individual. So in that case, I could draft the trust document and say that when I pass away, I want any money, but when the beneficiary passes away, I want any money in that trust to go support the ARC New York. However, with an ABLE account, even if I put my funds in an ABLE account for the benefit of someone else, those funds are always going to be subject to Medicaid payback. So that's important to keep in mind, especially for third parties who are evaluating ABLE accounts. And now I think we're going to open it up to some questions. Kind of as Sarah said earlier in the presentation, if you have some specific questions about a person that you're working with that you'd rather address with us offline, you can feel free to give us a call, visit our website, and we'd be happy to work with you. One question we received is, with the SSA approval, I'm assuming of the attorney's fees, will it guarantee payment to the attorney? So I have to say that this change in the POMs regarding the approval of attorney's fees is very new in the past month. So I think people who practice this type of law are really waiting to see how it's going to be impacted. I think that in an abundance of caution, it's probably the right idea to not assume that there is going to be approval of the fees. And kind of that's something that I know that we're keeping our eyes on to see what's going to happen. So one question that we received is whether a not-for-profit organization that serves as representative payee is the same as a trustee. And that is not the same as a trustee. Someone who's a representative payee is someone who's been approved by the Social Security Administration to receive Social Security funds on the behalf of the individual. But when those funds are received, they are not protected for the purposes of benefit eligibility. What that representative payee could do, though, is be part of the process of establishing and funding a trust to make sure that when those funds are received by the rep payee, they're put into the kind of appropriate vehicle to shelter those funds for benefit eligibility purposes. So we have one question about whether someone who has an individual SNT and lost their SSI could change that into a pooled trust. So there's kind of a few things that go along with that question. Kind of like how we talked about earlier, SNTs are irrevocable. So once the money is in the trust, you can't just take it back out. However, there are options sometimes to decant a trust or fully expend a trust. So kind of whether there is an option to get money out of an individual trust is going to depend on that specific individual trust document. So that's a question that if you want to send us a copy of the trust, we could look at it for you and let you know our opinion. Or you can see an attorney who might be able to give you some answers. We have another question about what would you consider a modest amount of money for a pooled trust? So that question, it really depends. I mean, everyone's definition of what is or isn't modest is going to vary. However, I think if you're going to be using an attorney to draft an individual trust, it's important to keep in mind that that's probably going to cost a couple $1,000s. So you want to have a cost-benefit analysis. Is spending $3,000 to draft an individual trust going to leave enough money left to fund the trust that it's going to be a benefit to the individual? So yeah, I would say keep in mind that an individual trust is going to cost a couple $1,000s and make an evaluation, let the family weigh in from there.
And this is Sarah. I would also add to that it's also taking a look at what their Medicaid lien may look like. An individual, whether it's individual or pooled, the money, requires a payback to the states. And so if the Medicaid lien is going to be significantly larger than whatever amount that you're looking to deposit into the trust, the individual may benefit from a pooled trust because they'll get more out of the money during their lifetime because of the lower fees and lower cost to establish it. And so if regardless, all the money is either gonna go back to the state or be retained because the lien will be so high, even a larger amount of money that well covers, you know, the initial cost of drafting a trust could be a good option, you know, just to consider and look at that as an option.
Yes, definitely. Another question we got is whether a representative payee can sign the joinder agreement on behalf of an individual, and unfortunately they can't. The parties that can sign the joinder agreement are defined by statute, and a representative payee is not one of them. A representative payee, however, can direct the funds that they receive from the Social Security Administration into a trust to fund it. So that is a way that they can kind of help if there's not someone to fund the trust, but there is someone to sign the joinder agreement. One question we received was, what is an MSA? I know we just touched on those briefly. Like I said, that's a conversation for a whole other presentation. But an MSA is a Medicare set-aside. And in that situation, you have someone who has a settlement that says that funds should be used to pay for things related to their injury in anticipation of Medicare picking up that cost later in their life. So that's something that you'll be told there's an MSA involved in the case. You won't need to figure that out on your own. One question was, what's an annuity? Annuity is an aversion, it's a financial tool that can be used to fund someone's settlement, but with an annuity, you're gonna have some sort of periodic payout. So it's kind of creating an income stream as opposed to creating a lump sum amount of money, which is part of why that income stream, that periodic payment, needs to be irrevocably assigned to whatever special needs trust you're working with. So one of our questions is, who oversees how funds in a special needs trust are used? There is no specific kind of governing body that oversees how SNTs are used, but there are a variety of different agencies and organizations that are involved that might have something to say if someone just takes money out of their SNT and goes and spends it on whatever they want. One organization is going to be your local DSS office. When someone is recertifying or applying for Medicaid or other services, the local DSS office could and often does ask for documentation about how funds in an SNT are being used. For some people who have a court-ordered settlement, or they have a court-ordered guardianship, or some way in which a court is going to have continued involvement in their trust and in their life, there are often annual accountings that need to be filed with that court, which will specifically say how the money was used, and the court would say, well, what was that money used for? Give us receipts, show us how that money was used appropriately for the individual. And then kind of overarching, the Attorney General's Office Charities Bureau is the wing of the government that sometimes gets involved when there are issues with someone's trust. So there are a lot of checks and balances, particularly when it comes to someone's eligibility for government benefits, where the use of their funds in their trust could be questions or asked for documentation. And one of the benefits of using a pooled trust or having some other form of professional trustee is that you have the peace of mind of knowing that if an organization or a government entity asks you for information about how the money in the trust was used, that professional trustee is going to have that documentation available to provide when asked. And that takes some of the burden off the family to make sure that they are preparing that documentation.
And the second part of that question is if someone, an individual as in the trust beneficiary, could get, let's say, $2,000 out of the SNT to go spend it on whatever they want, and who's monitoring that. And so the answer there is the trustee. So whether or not it's an individual family member serving as trustee or a professional trustee who's overseeing the management and administration of the account, that's going to, be the individual that, is going to be responsible for allowing payments out of the trust. And as we referenced earlier, you can never give money directly to the trust beneficiary in the form of cash or any easily liquidated asset, because that would reverse the protections that we created by depositing those funds into the trust. That would make those funds available to that individual, and therefore it would not protect their eligibility for benefits. And so you can, the trustee is never going to just hand $2,000 to the trust beneficiary to go out and spend, but they will review requests to make payments and make payments to third parties.
And I think that brings up an important point about choosing a trustee if you're going with an individual trust, that if a family member is serving as trustee, it might be difficult for them to say no when their loved one asks for $2,000 or asks for something else that they really, really want, but the trustee knows is not going to be appropriate in terms of protecting their benefit eligibility. So if you think that someone you're working with is going to have that kind of situation with their family, using a professional trustee who kind of gets to be the quote unquote bad guy and say no can actually be really beneficial for the family, because then it doesn't add that kind of strife into the family dynamic and lets the trustee do their professional duty. One question we got is that if someone works and makes enough wages that they lose their SSI, whether they could deposit their paychecks into the trust to maintain their SSI. So with SSI, no. SSI has pretty strict income and resource limits. So if someone is making too much money to lose their SSI, they can't use the trust to shelter that income. However, if someone loses their SSI but still needs their Medicaid, and they have too much income for Medicaid purposes, if they're eligible for the Medicaid buy-in program, which is a program that's designed to let people with disabilities be able to work and be integrated into their community, they could potentially participate in the Medicaid buy-in program and still get their eligibility for Medicaid, and then shelter some of their excess income in a pooled or individual SNT. So that is something that's an option for some people. One question is that if an individual has a trust, could they move some funds into an ABLE account? The answer to that question is yes. The mechanics and requirements of how that would happen is really going to depend on the trustee, the pool trust you're working with, things like that. But the government has said that it is appropriate and okay to move funds from an SNT into an ABLE account.
And how we see that, happening around the country is more for a specific purchase than putting a bunch of money into an ABLE account for someone to use. Many trusts will consider something like paying for a housing expense and will, on a regular basis deposit funds into an account to be specifically used for that purpose. Because I think that one of the things that is somewhat challenging for the trust or the trustee is to, they have a fiduciary responsibility to ensure that those funds are used appropriately. And so, making sure that the proper documentation is collected and, the oversight is maintained that that money is used for the expense it was intended for, or an appropriate qualified disability expense. And so that's somewhat new, and I think you'll see more of that develop over the next couple of years, decade, as the ABLE accounts become more readily used.
Yes, definitely. We have another question about ABLE accounts, is that if there's an age requirement to be able to set that up. So with an ABLE account, when someone's under 18, technically their parents are their legal guardian. So for a minor, they're not going to be able to establish their own ABLE account. But once someone has reached the age of majority, they are going to be able to establish their own ABLE account. We have one question that is about our trust programs, whether someone can have a Community Trust 1 and a Community Trust 2. That would be a situation where someone is sheltering excess resources and excess income. At least how we administer our program, we would let them have one account to serve both of those purposes. That's easier for the individual. It makes tracking the activity easier on our end. So we find that that is a better fit. One question about ABLE accounts is that where do we go to set up an ABLE account? So there are ABLE programs administered by different states across the country. There are some minor differences. In New York State, you can go to mynYable.com. excuse me, and that's the website for the New York ABLE program, and that'll give you some information about that program and the forms and all that information to sign it up.
And it's important to point out that you do not have to use your own state's program. You can use another state's program. So it's worth, you know, looking at some different options to see what meets your specific needs or the needs of a person that you're working with.
One question was whether the parents of an adult who are not legal guardians or POA can set up a trust, or if they have to be the legally responsible for the person. The statute does say that parents can sign a joinder agreement, parents or grandparents. They can sign a joinder agreement for a pooled trust, but it's going to be different, I think, for an individual trust. So there is one question about if someone needs to get their trust approved by the Social Security Administration, where they send that to. That's going to depend on your Social Security region, and you're going to send it to their regional office. So for New York State, the regional office is in New York City. And it is an obligation to send the trust to them for approval. If the Social Security Administration does not approve of the trust, that protection that you're trying to create could not work. It could be rejected and that person can have an issue with their benefits. Another question about ABLE accounts. Can a New York College 529 account be changed into an ABLE plan? Yes. The state has said that up until, I believe you have until the end of the year in 2021 to transfer funds from a 529 college account into an ABLE plan without any tax repercussions or anything like that. But after that point in time, they're not going to be able to do that. One question is, what is the minimum amount to establish a NYSARC pooled trust? For Community Trust 1 and Community Trust 2, so that's our trust for someone who has a lump sum of money to shelter under $250,000 or who has an income spend down, it's a minimum opening deposit of $300, which makes it very accessible. But for that Community Trust 3, it does have to be a minimum of $250,000. We have a question just for the ABLE account information. It's mynYable.org. I'm sure if you just Google New York ABLE accounts, it's going to be one of those top hits there if you don't remember that in the future. But that's where you can find information about the ABLE program. We have a few more questions about someone losing their SSI and whether they're applicable to use the Medicaid buy-in program. That sounds like a really fact-specific thing, so please contact us offline, and we can kind of go more into the details about your particular client. But the Medicaid buy-in program is only available to certain individuals, so that's not going to be available to everyone. We have a question again about ABLE accounts, about whether a parent can open an ABLE account for the disabled child. The answer is yes, a parent can do that. And it looks like that's all the questions we have for now, but we can leave the questions open for a little bit if more people want to answer questions. And then again, you know, once we end this presentation, we really encourage you that if you have other questions, if you need some more information, to please reach out to us and we'd be happy to help.